Lordships may allow, the petitioner will start. Warm greetings to the Honorable Bench. May it please the Honorable Bench, this is Counsel number 1 appearing on behalf of petitioner in the case of ESCO versus Union of India. Council recognizes the gracious presence of your ladyship. However, for the convenience of the proceedings, the Council seeks the permission to address the bench collectively as your lordships.
You can
I don't know
choose
how
to
to
do
react to
just
that, but please, whatever.
you can choose to do just your honor or sirs. That is it. Don't
I
need to
think
say
that
even the lordship. That's not even required.
Much obliged, Your Honor. The petitioners have approached this honorable court under writ jurisdiction of High Court under Article 226 of the Constitution of India. We request the honorable bench to issue a writ of mandamus against the respondent, declaring the provision of GAR as constitutionally invalid. The first issue will be dealt by Counsel 1 and I will be taking 11 minutes for this submission. Further, my co-counsel would be dealing with issue 2 and will be taking 14 minutes. Further, we would like to reserve 3 minutes for rebuttals. If Your Honor do not have any preliminary inquiry, the counsel seeks permission to begin with the set of arguments.
Please do.
Much obliged, Your Honor. The counsel would be putting forth the argument that uncertainty in GAR leads to the violation of rule of law. The council would like to draw your lordship's attention to page 1, para 3 of memorial submission. The council humbly submits that Sir A.V. Dicey, while enumerating the ingredient of rule of law-based legal system, said that wherever there is discretion, there is room for arbitrariness, and that in a republic no less than under a monarchy, discretionary authority on the part of government must mean insecurity for legal freedom on the part of its subject. The council humbly submits that the Supreme Court, in the case of Rashlal Yadav versus State of Bihar, has categorically held that fairness and reasonableness must be the pivotal touchstone to check exercise of wise discretion vested with administrative authorities, a test which squarely applies to tax administration in the wake of wide powers conferred by statutory GAR. The Supreme Court even went on to say that the rule of law doctrine forms the part of basic structure of our constitution in the case of I.R. Kohlo versus State of Tamil Nadu. Therefore, it is submitted that as rule of law constitutes the part of basic structure of our constitution and GAR provisions violate the rule of law principle, thereby the GAR provisions violate the basic structure of our constitution. Moreover, the council would like to draw lordship's attention to page 3, para 13 of memorial submission for the petitioners. It is humbly submitted that the Honorable Supreme Court in the case of Braj Mohan Lal versus Union of India declared that arbitrariness, unfair actions or policies contrary to the letter, intent and philosophy of law and policies would not be tolerated even in context of fiscal statutes. I would like to draw lordship's attention here. The court specifically mentioned that even in case of fiscal statutes, there should not be any uncertainty and unfairness. The council would like to draw lordship's attention to page 4, para 15 of the memorial submission. It is humbly submitted that Section 96 of Income Tax Act lays down the conditions under which a transaction can be declared as an impermissible avoidance arrangement. It lays down 4 conditions. Firstly, if a transaction creates rights and obligations which are not normally created between party dealings at arm's length, or if a transaction results in misuse or abuse of provision of tax laws, or if a transaction lacks commercial substance or is deemed to lack commercial substance, or if a transaction is carried out in a manner which is normally not employed for bona fide purpose. An important point to note here is that in these conditions need not be fulfilled simultaneously but individually. Thus, if any one of these conditions is met, then the principal commissioner has the power to declare the transaction as IAA, which is impermissible avoidance arrangement. Also, it is pertinent to note here that The ambit of fourth condition here is very wide. The words used in the fourth condition, such as normally not employed for bona fide purposes, gives such unfettered power to the principal commissioner to impose this condition on any transaction according to his whims and fancies. According to Section 144BA of the Income Tax Act, the principal commissioner, who has been conferred with the power to arbitrary power to declare a transaction as IAA and impose the provision of GAR on it. The conferment of this discretionary power is against the principle of rule of law and leads to arbitrariness. It is further submitted that subsection 2 of section 96 of Income Tax Act presumes that a transaction would have been entered by the assessee for the main purpose of obtaining tax benefit, and the onus to prove contrary is on the assessee, which is against the principle of e incubit probatio qui dicit non qui legat, which means that the onus to prove the guilt of accused lies on the person who affirms it, not on the person who is defending it. Section 96 also codifies the doctrine of substance over form. The Council humbly submits that Honorable Supreme Court in the case of Vodafone versus Union of India ruled that department must employ the look at test by looking at the transaction holistically rather than look through test by splitting or dissecting the transaction. The court advised against the authorities reaching any premature conclusions premised on suspicions, such as cautioned against the applying the principle of substance over form until evidence was found indicating the duplicitous nature of the transaction. Therefore, the formulation of section 96 subsection 2 goes against the precedent set by Supreme Court of India. The Council humbly submits that once the provision of GAR is invoked, it grants the government unfettered authority to recast a transaction for tax purposes or to vary the applicable tax consequences. The provisions can be seen as authorizing a form of taxation by administrative decree or analogy, or even worse, the imposition of what may amount to incontestable tax. The Council would like to draw Lordship's attention to page 6, para 26 of the petitioner's memorial submission, wherein the case of Queen versus Canada Trustco Mortgage Company, the Supreme Court of Canada extensively examined the principle of literal interpretation of fiscal statutes and also noted the fact that the Inland Revenue Commissioner versus Duke of Westminster principle was still applicable, which means that the taxpayers are entitled to arrange their affairs to minimize the amount of tax payable. The Duke of Westminster principle is also applicable in India. The Honorable Supreme Court, in the case of Azadi Bachao Andolan, the court imported the application of Westminster principle to conclude the DTA would fall under the ambit of the principle and therefore allowed the parties to claim minimum tax liability. The court further upheld the validity of Westminster principle and has observed that in history of Indian fiscal jurisprudence, the principle has been held good. Therefore, the Council submits that there exists uneasy tension between GAR and rule of law, and that from the rule of law perspective, the application of GAR suffers mainly three ills. Firstly, instead of tax being imposed under through law parliamentary process, it is imposed by way of administrative discretion conferred on the authorities under GAR. Secondly, when the law has been enacted by the parliament and the taxpayers has acted to undertake transaction on that basis, it is not proper for the government to vary the consequences of this transaction by applying GAR subsequently. Thirdly, taxation laws are required to be stated with certainty such that the taxpayer can address their transaction sufficiently. Therefore, the provision of GAR goes against the principle of rule of law and are against the basic structure of our constitution. Therefore, the council requests this honorable bench to uh, to declare that the GAR law is constitutionally invalid and liable to be struck down. If your lordships do not have any inquiry, I would like to invite my co-counsel for presenting the argument's second argument.
She can start. We can also have it unless the brother Justice Valmiki has some question.
Your Lordship, you are not audible.
Please go ahead. We'll hear the lady first. Thanks.
Good morning, Your Honors. This is Counsel number 2 for the petitioner, and will argue on issue number 2, that is, the specific anti-avoidance rules in the Double Tax Avoidance Treaty will override the general anti-avoidance rules in the Income Tax Act in the present case. Your Honors, the Council seeks to argue the issue with a four-pronged argument. The first contention being that a domestic legislation cannot unilaterally override international treaty and bilateral agreements. The second, that unilateral modification of a treaty is a blatant violation of the VCLT and the principles of customary international law. Thirdly, that Article 253 of the Constitution prevails over Article 245 and 246. And fourthly, applying a general law where a specific law is already present on the same issue goes against the basic tenets of the law and is a violation of the principles of natural justice. Finally, Your Honors, the Council will also, with the permission of the court, proceed to show to the bench how, in the given factual scenario, the income tax authorities have total absence of jurisdiction and authority of law in invoking GAR in the transaction in question. Your Honors, the Council mostly humbly submits, according to Section 90, subsection 2, when determining an assessee's tax liability in connection with an international transaction, the provisions of the DTAA that are more beneficial to him will take precedence over the inconsistent provisions of the Income Tax Act. The Council would like to draw Your Honor's attention to page 8, paragraph 36 of the memorial submission, where the Supreme Court had applied the same principle in the case of Engineering Analysis Center of Excellence Private Limited versus the Commissioner of Income Tax. My Lordships, to overcome this principle, the legislature brought in Section 90, subsection 2A, with effect from 2017, and which states that notwithstanding anything contained in subsection 2 of Section 90 of the Income Tax Act, the provisions of Chapter 10A of the Act shall apply to the assessee even if such provisions are not beneficial to him. And by way of this, the government tried to put forth that any consistency between the DTAA and the Act, according to the provision of the Act, will now according to the provision of the Act will now prevail, and the assessee will be denied any tax benefits under the DTAA. Your Honors, it is a well-established legal principle that the scope of a non-obstante clause must be understood in its context, as subject to the principle of harmonious construction. Lordship, a special provision cannot be overridden by a later general provision simply because such provisions begin with a non-obstante clause. Furthermore, Your Honor, in the case of Director of Income Tax versus New Sky Supply, the Delhi High Court stated unequivocally that no amendment, whether retrospective or prospective, could be read in such a way that the operation of the terms of international treaty is altered. A domestic law remains static for the purposes of a DTA, and it is also stated that while Parliament was supreme, it was simply not equipped to change or nullify the terms of a treaty through domestic law. With Your Honor's permission, Counsel wishes to present his second argument.
Yes, please go ahead.
Counsel will now make the case that unilaterally modifying a bilateral agreement is a clear violation of the Vienna Convention on the Laws and Treaties, as well as principles of customary international law. Your Honors, the Council would like to draw your attention to page 9, paragraph 38 of the memorial submission, where the Honorable Delhi High Court stated in the case of Director of Income Tax versus New Size Satellite that the provisions of the VCLT were universally accepted as a part of customary international law. Article 39 of the VCLT states that no treaty can be unilaterally modified by one state. This means that any changes or effects to the treaty can only be made the agreement of the parties. Your Honors, the Delhi High Court in the same case observed that the principle that states are expected to fulfill their obligations under a treaty in good faith, and this includes the obligation to not defeat the purpose and object of the treaty. Further, even Article 51, Clause C of the Constitution mandates fostering respect for international treaty, and thus legislative powers of the Parliament are limited in this regard. Your Honors, the Council will now proceed to the third contention, which is that how Article 253 of the Constitution supersedes Article 245 and 246. Article 253, Your Honors, establishes an important principle in dealing with India's international obligations. It states that notwithstanding anything else in the chapter's provisions, the Parliament has the authority to enact legislation to implement any international treaty or agreement. And Section 90, subsection 2 of the Income Tax Act is an example of this. Clearly, Your Honors, the non-obstante clause in Article 253 means that it prevails over the other articles. Section 90, subsection 2 of the Act has been enacted under the exercise of power under Article 253, whereas Section 90, subsection 2A of the Act has been of the Income Tax Act has been enacted by exercising the power under Articles 245 and 246 of the Constitution. Honors, since Article 253 overrides 245 and 246, the law that is made under under Article 253, which is Section 90, subsection 2, should also prevail over Section 90, subsection 2A, which has been made under Article 245 and 246. Your Honors, in the case of Sanofi Pasture Holding SA versus the Department of Revenue, the Andhra Pradesh High Court ruled that a law made under Article 253 cannot be amended or overridden in subsequent statute made under Article 246, and that the overarching principles of international law continue to limit a country's ability to unilaterally amend or repeal treaty provisions. Your Lordship, Your Honors, the Council will now present his fourth argument. Your Honor, the basic law, any tax law, are certainty. If the government starts applying a broader general law, override any special provisions already provided for an issue, when there are specific guidelines already made and already agreeing between between the states, if it starts questioning everything for which a special rule is made, then on what basis can anyone ever decide anything and whether to take any commercial action or not? Your Honors, it is humbly submitted that the Latin principle, lex specialis derogat legi generali, becomes applicable, which means that specific principle will prevail over the general principle. And it ensures that where a law has been enacted to deal with a specific matter, such matter, once dealt with through the operation of the specific law, is not relooked at again through the lens of the other more general laws. In your Lordship, a general rule which is adopted is one of harmonious construction, whereby uh, whereby the general law, to the extent dealt with by the special law, is impliedly repealed. Now, with your Honor's permission, the Council will now demonstrate how this transaction falls outside the scope of GAR.
Yes, please. Please go ahead.
Right, Lord. To begin with, the Council contends that the Indian tax authorities lack the jurisdiction to intervene in any commercial decision made by the company. Lordship, the merger of ENCO, the Netherlands entity, into ESCO, according to the AO, was done to obtain a tax benefit. This argument, Your Honor, is devoid of any logic. If ENCO would have sold the shares directly to EFCO, instead of shifting its base to Singapore after 10 years, it would have had no tax liability in India because Article 13.5 of the India-Netherlands Treaty states that the gains from the alienation of any property other than the specified are taxable only in the state in which the alienator is the resident. Further, in the instant case, ENCO has merged with ESCO, and ESCO thus grandfathered ICO's share. Article 13.4a of the India-Singapore Treaty, Your Honors, now applies, and the subject to the LOP provisions, gains from the alienation of shares acquired before 1st April 2017 in a company resident of a contracting state will be taxable only in the contracting state in which the alienator is a resident. Honors, which aspect of the transaction are the respondents questioning for tax evasion? Is the merger being undertaken to avoid paying taxes, or is the transfer of the Indian entity from the Netherlands to Singapore considered tax evasion? Any scenario, Your Lordship, they cannot question because India was never set to receive any tax from this transaction, irrespective of the fact whether the Singapore entity or the Netherlands entity would have sold the shares. There is absolutely no reason for the Indian authorities to interfere in this. Further, Your Honor, to apply GAR, there has to be a series of transactions for which the intention is to obtain a tax benefit. Intention here is a very big thing. If the respondents are contending the tax benefit is of the capital gains on the selling of shares by the Singapore entity, then the intention of the merger cannot be questioned at all, as there is no tax liability irrespective of whether the merger took place or not. The Council would like to draw the kind attention of the bench to para 3 of the Moot proposition problem. The primary purpose to undertake the transaction is not to avoid tax, but rather due to a restructuring which was necessitated due to UCO selling the shares of an entity not connected with India. Further, Lordships, we were getting tax benefit in the Netherlands as well as Singapore, and even then we shifted from Netherlands to Singapore, and therefore Our intention is here is not to indulge in tax evasion. Furthermore, Your Honor, according to para 4 of the Moot problem, ICO declared and paid dividend to ESCO, which according to the Singapore Treaty, India can withhold tax at either 10% or 15%, depending upon the situation. At the same time, Your Honors, the Netherlands Treaty contains the most favored nation clause, which states that if India enters into a treaty, any OECD member, for an and the treaty has a lower dividend withholding tax rate, then the same will automatically apply to the Netherlands Treaty also. By virtue of this, Your Honors, Netherlands Treaty only, according to the Netherlands Treaty, the Netherlands only withholds 5 to 10% tax, which is much lesser than the Singapore Treaty. If the intention of the petitioner was to obtain a tax benefit, Your Honors, then why would we have left the tax-friendly jurisdiction for Singapore, Your Honors? Your Honor, it is the assessee taxpayer's right to organize his affairs in a manner which is most beneficial to him. If the shifting to Singapore was necessitated by restructuring, how can the AO question that, and how can the intention for tax evasion be proved here? Furthermore, Your Honor, the fact that the time period for holding the shares is approximately 10 years, including grandfathering, supports the contention that there is no malified intention to obtain any tax benefit. So if Your Honors kindly refer to page 15 of the memorial, paragraph 66. Established that the investment participation time test in the case of Commissioner of Income Tax International Taxation versus JSH Mauritius Limited, and observed that in the particular case, 13 years was considered to be a sufficient period to hold shares, and such a long holding period in a case demonstrates the company's genuine intention. In addition, Your Honors, the legal requirements under the Singapore Treaty, including compliance with the LOB clause and obtaining a valid TRC, which is tax residency certificate, have been met. Furthermore, it has been clearly stated in the case of Union of India versus Azadi Bachao Andolan that a certificate of residency issued by a competent authority shall constitute a valid evidence for determining the residency for the purposes of a DTAA. The AO's refusal to acknowledge the presence of a valid TRC and compliance with all treaty requirements before invoking bar on the petitioner is absurd and unjustified. With this, Your Honors, the counsel would like to conclude his arguments and, with the permission of the court, proceed to the prayer.
Yes.
Wherefore, in the lights of the facts stated, arguments advanced, and authorities cited, mostly humbly prayed and implored before this Honorable High Court of Bombay, may be graciously pleased to adjust the following order. First, to declare that GAR provisions contained in the Chapter 10A of the Act are constitutionally invalid. Second, to declare that the specific anti-avoidance provisions contained in the DTAA will override the GAR provisions in the Act. Third, to set aside the impugned order passed by the AO and to decide other issues in favor of the petitioner. Fourth, for costs of and incidental to this petition, and or pass any other order that the Honorable Court may deem fit in the favor of the petitioners to meet the ends of equity, justice, and good conscience. For this act of kindness, petitioners shall duty bound forever pray. Thank you, Your Honors.
You would say that the application of this GAR provisions by the concerned assessing authority should be in accordance with the time-tested and well-settled legal proposition of legitimacy of tax planning within the four corners of law. And that is what you have done, right?
Yes,
And,
yes, Your Honor.
and what would you say about the Inland Revenue Commissioner versus Duke of Westminster, which says every man is entitled, if he can, to order his affairs so that the tax attaching under the appropriate tax is less than it is otherwise would be. If he succeeds in ordering them so as to secure this result, then unappreciative the Commissioner of Island Revenue or his fellow taxpayer may be of his ingenuity. He cannot be compelled to pay the increased tax. That is the sum and substance of your submissions.
Yes, Your Honor.
Yes. All right, brother, if you need to just say anything or ask the question.
Can I just have a clarification from you?
Yes, Your Honor.
Yeah. Your argument appears to be that basically the entire chapter 10A is what you want basically struck down besides section 92A. Um, uh, if you read section 95, the first section of chapter 10A, does it really in any way militate against the DTAA with that country, or does it only restrict itself to going after your arrangement? You know, the arrangement that you have of the transfer of shares, does it is it only restricted to your arrangement and in no way militates against the double taxation avoidance agreement with that country? So would they not stand in two separate? Uh, uh, the power is not isn't the power just restricted to analyzing your arrangement, and not in that sense negating the double taxation avoidance agreement?
Pertinent question, Your Lord. Your Lordship, basically, Section 95 of the Act says that notwithstanding the provisions of the Act, any arrangement or a step in or any part of the arrangement uh, may be scrutinized by the department to determine the tax avoidance. Your Lordship, the AO in this case is doing that he is not understanding that this whole arrangement was not done with the objective tax evasion. He's looking only at particular part of it, which is that the shares were sold from the Singapore entity to the French entity of the Indian entity shares were sold by the Singapore entity to the French entity, and it is only looking at that aspect of the transaction. And this is where the problem is. It This problem with the GAR provisions is that allows the assessing officer to look at a partial aspect of a transaction instead of looking at the complete picture. Your Lordship, in our case, this whole arrangement started 10 years ago when GAR was not even applicable in India. Neither there was any sort of clarity on this law, on this particular law. Then this arrangement started, and due to commercial reasons, this whole arrangement was done. Now, if the AO just picks up one part of the transaction, and then says, "Oh, you have done this for tax evasion," how is it justified, Your Lordship? Your Lordship, you are
Would
not
you
audible.
Am I audible now?
Yes, Your.
Yes. So the question still remains. I'm sort of separating the challenge to the virus of the whole provision from challenge to the order as such. I think you're challenging besides throwing a challenge to the order itself, you're also challenging the virus of the very provision, saying that that order itself, the basis of the order itself, you're trying to knock that out. So, separating the two, would the order, if your challenge to the virus fails, would the order not be sustainable, or the power that the AO or the commissioner here exercise, would it not be within the bounds of Chapter 10A?
Even if the virus of the case against the virus of the act fails, even then the AO's order is bad in law, Your Lordship, because of the fact that he is despite if you see from the facts, Your Lordship, that there was dividend paid from the Indian entity from by the Indian entity to Singapore entity, and the AO did not challenge this, and AO did not verify this. It could have the intention of the petitioner here is clearly visible by the fact that the AO did not challenge this part. Since AO did not challenge this, this means that he accepts the fact that the treaty provisions are applicable on the petitioner, and the treaty benefits are available to the petitioner. And then even after that, after not he is not verifying whether the compliances have been fulfilled. He is not ready to accept that the petitioner has complied with the treaty provisions and is entitled to the benefits under the treaty, the tax benefits under the treaty. He is still not verifying. He accepts by the fact he's not contesting the fact that Indian entity has paid dividend to Singapore. He's not contesting that in the facts. And then even that when he accepts that impliedly that the treaty is available, the treaty benefits available. Still, he is not providing this. He was still at fault here.
Thank you.
Would he not, I mean, taking it from there, would he not be entitled to do that? The AO, suppose, as
Your
Brother
Honor.
Justice Valmiki has asked you, if your virus challenge is something not sustainable, the court finds that is not sustainable, then would, under the domestic law, the AO would not be entitled to even look at it as to whether this was done with a purpose of tax avoidance?
Your Honor, the AO, uh, the petitioner is contesting the very fact that the AO's order is bad in law because he is not ready to accept the facts apparent. Since he is impliedly accepting that the treaty benefits are available, and then he is not providing it to the petitioner, Your Honor.
Even if the benefits are available, his premise also is that this is just to avoid the taxation, and this is something you can plan it, but you cannot avoid it.
Lordship, Your Honor, he is looking at the transaction from a particular aspect, a part. Lordship, this should not sustain the challenge because because Your Honor, that looking at a particular part of a transaction, it in itself, and then determining whether this is for tax avoidance or looking at the whole picture is very different, Your Honor. When we have submitted to the AO that the whole transaction is not for tax avoidance, and even then he is not ready to accept, then Your Lordship, AO's order is definitely bad in law. If he looks at the impermissibility, he tries to call this arrangement an impermissible avoidance arrangement, it would still be bad in law and bad in practice also, Your Lordship. AO order holds no substance.
Thank you, brother. That's all from my
Thank you.
side. Would you like
I
to?
think that's all from my side as well. Thanks. Thank you.
The counsel for the respondent seeks permission to begin your lordships.
Please do.
Am I clearly audible and visible, your lordships?
Yes, you are.
May it please this honorable court, this is counsel appearing on behalf of the respondent in the case of X Company versus Union of India and others. Your lordships, I'm representing Union of India and others and would be replying to the issues raised by the petitioners. Your lordships, with your permission, I would like to state my first issue in hand, your lordship. Your lordship, my issue deals with whether the guard provisions contained in Chapter 10A is constitutionally valid or not. Your lordship, the counsel for the respondent would like to humbly contend that the guard provisions contained in Chapter 10A is constitutionally valid. Your lordships, I would like to substantiate this contention with threefold arguments. Firstly, the interpretation of treaties in good faith. Secondly, the intention behind guard provision and the the approach of doctrine of substance over form in the guard provisions. And thirdly, the power of Parliament to make laws under Article 245 and 253, Your Lordships. Your Lordships, to begin with my first limb of my argument, the interpretation of treaties in good faith. Your Lordships, I would like your Lordship's attention to Article 31 of the Vienna Convention. Your Lordships, this article provides stipulates that the treaties are to be interpreted in good faith, Your Lordship. In addition, the OECD's commentary under Article 1 held that the treaty benefits should not be granted where the sole purpose of an arrangement is to obtain a more favorable tax position. Your Lordship, this would not amount to a unilateral change or treaty override since the purpose of the treaty is not frustrated here, Your Lordship. In addition, the use of a company to obtain the tax benefit has been recognized as an improper use by both OECD and UN recommendations. I would also like your Lordship's attention to the OECD recommendation, which recommends the denial of treaty benefits if any substantial interest in the company is owned by the residents of a third country. Your Lordship, for this, I would like to draw your Lordship's attention to paragraph number 5 of the Moot proposition. Yeah, it states that in 2020, S company sold shares in India company to a third party French entity, F company. Your Lordship, as per this fact, we could conclude that the substantial interest in the company is owned by a resident of a third company, which is the French entity F company. Hence, Your Lordship, the denial of treaty benefits in this case is valid, Your Lordship. By this interpretation of laws in good faith, I would like to move on to my second limb of my argument, the intention behind guard provision and application of doctrine of the substance over form, Your Lordships. Your Lordships, the income tax authorities are losing income tax revenue because of an aggressive income tax avoidance planning by individuals or companies. Hence, Your Lordship, the guard provisions are introduced in India for avoiding the income tax losses through an income tax avoidance, which are planned by those individual and company. In addition, Your Lordship, the GAR provisions have been introduced to restrict the assessee from making any artificial structure or using colorable devices to take advantage of the tax benefits or to reduce the tax liabilities offered under various treaties. Also, Your Lordship, this chapter 10A states that to avoid tax, the assessee cannot use the impermissible avoidance agreement. Your Lordship, this agreement can only be formed to derive the tax benefit, and further, the assessing officer may presume that the main purpose of the arrangement is to obtain tax benefits only by showing that any step in the arrangement was taken to obtain tax benefit, Your Lordship. With that, I would like to apply the doctrine of substance over form to the intention behind the guard provisions. Your Lordships, the net effect of GAR provision, as stated earlier, is to disregard the legal form of these transactions and look only at the substance, that is the commercial substance, and tax the entirety accordingly, Your Lordship. Obviously, Lordship, these relate to a specific set of transactions which are entered into with the only significant objective of reducing the tax liability. Your Lordship, the general perception of the GAR is that there is no room for any tax avoidance, and the gap between tax avoidance and tax evasion is effectively bridged by introducing the GAR provisions. Also, Lordship, in this GAR provision, the concept of impermissible avoidance arrangements, it envisages the situation where an arrangement's main purpose is to obtain a tax benefit and it lacks commercial substance. Hence, Your Lordship, not all the time the GAR is invoked. It is framed only in good faith and invoked only when the situation where an arrangement's main purpose is to obtain the tax benefit and lacks commercial substance. With that application, Your Lordship, the GAR provisions have been invoked with an intention of good faith as to avoid the tax misconceptions as stated earlier. With that, Your Lordship, I would like to state my third limb of my argument, the power of Parliament to make laws under Article 245 and 243. Your Lordship, this Parliament has power in Article 245 as well as Article 253 to make laws. But Your Lordship, first interpreting Article 245, it has the phrase subject to the provision of Constitution. Your Lordship, this phrase can be interpreted in three things. Firstly, the provisions under Part 3. Secondly, the division of legislative subjects between Parliament and the state legislative. And thirdly, any provision of the Constitution which may impose the restriction, Your Lordship. From this, also, Your Lordship, I would also like to interpret Article 253. Your Lordship, the powers conferred under this Article 253 are also conferred under entries 10, 14, 15, and 16. Among the other list, in the list 1 of Schedule 7 of the Constitution, Your Lordship. Therefore, the privileges to Article 253 and 245 by virtue of this non-obstant clause present in Article 253 would lead to an uncertain situation wherein the laws formed on the same subject matter is also be superseded, Your Lordship. For this, I would like to quote a Supreme Court case, State of West Bengal versus Kesoram Industries. Your Lordship, the Supreme Court stated that the India obeys the doctrine of dualism and stated that the treaty has been entered into by India cannot become the law of land. Your Lordship, from this we can infer that the the treaties which have come to India has cannot become the law of land. Also, your lordships, it is your lordships kind attention that India is not a signatory of Vienna Convention. It is only the Supreme Court has in various precedents held that the treaties can only be interpreted as a guideline to interpret those treaties, and it is not completely binding on the country, your lordship. In addition to that, I would like to bring your lordship's attention to Article 28A of the DTAA between Singapore and India. Your lordship, the agreement, that particular article provides that the agreement shall not prevent a contracting state from applying its domestic law and measures concerning the prevention of tax avoidance or tax evasion, which in this case, your lordship, the domestic law, which is GAR, is not being restricted by the treaty signed by Singapore and India itself to not bar the usage of domestic laws in this case, your lordship. Hence, your lordship, from this, I would like to hence contend that the GAR provisions are constitutionally valid as Article 253 and 245 are at the same footing. The non-obstant clause under Article 253 does not provide any precedence over Article 245. Your lordship, before concluding with my argument, though, I would like to I would like to oppose the contentions put forth by my opponent counsel, where they stated that the rule of law is being violated and fundamental rights are being violated. Your lordship, the Singapore company is a resident of Singapore. Hence, your lordship, the fundamental rights are not applied to any person who are citizens other than India. Fundamental rights are applied only to the citizens of India, your lordship. But however, your lordship, the country is bound by the national treatment principle, which I would like to point here. And your lordship, as per this national treatment principle, the country gives the same treatment which is given to the Singapore company as it would give to India company. There is no separate provisions for India and foreign companies. The country uses the same provisions with the GAR provisions for every other countries as well as India company, and hence, your lordship, there is no violation of rule of law in this particular case, your lordship. Hence, your lordship, for the purpose of argument, I would like to state on the behalf of the respondents that the GAR provisions are drafted in good faith as to avoid the improper usage of the tax benefit, allowing the tax authorities to ignore the legal form of an arrangement and look into the actual substance, your lordship, in order to prevent the artificial structure from being used for tax avoidance purposes. Hence, your lordship, the counsel for the respondent humbly submits that the constitutional challenge of the GAR provisions is likely to fail from the above stated arguments. If your lordships have no further questions, I would like to leave my podium to my co-counsel.
Let her continue.
Yes,
Madam,
madam, may I just ask, since you are on the you rejoined to sorry, you replied to the argument of the, I think, the second counsel for the petitioner on the question of the non-obstant clause in Article 253.
Yes.
Now, Article 253, basically Section 90, as it stood before the amendment, putting subsection 2A, the legislation as it stood then, would the non-obstant clause not bar introduction of section chapter 10A through Article 246? What's your argument specifically in reply to his argument on the non-obstante clause?
Your lordship, the non-obstant clause specifically says that the treaty has to be according to that particular chapter of the constitution, your lordship. But however, your lordship, the treaty signed by Singapore and India, the DTA agreement, Article 28 clause A of that particular agreement stated that the agreement shall not prevent a contracting state from applying its domestic law, which, your lordship, the country has abided by the international law and treaty obligation, and hence only has introduced this GAR provisions, your lordship. And also, your lordship, this GAR provision has not been introduced to restrict those international obligations, whereas it is only introduced in good faith, Your Lordship. If that answers Your Lordship's question.
No, my query was slightly different. There's a challenge to the virus of the introduction of the whole chapter 10A. Basically, that seems to be their argument. And if that chapter doesn't exist and subsection 2A doesn't exist, the AO would not have the jurisdiction to even examine the arrangement that has been made. So my question specifically is not about the specific clause of the double taxation agreement, but in relation to the power to legislate and bring on the statute book the whole chapter 10A without looking specifically at Singapore. How does your argument stand in relation to every DAT agreement?
Your Lordship, first I would like to state that Article 240, 245 and 253 are, though they have different nature of legislative powers, they are at the same footing only, Your Lordship. Since, Your Lordship, India is a country which is not a signatory of Vienna Convention. Hence, to any treaties, India is not compulsorily bound to. It only has the discretion, and every other international treaties are only used as a guideline and not merely binding. Hence, Your Lordship, the powers under both 245 and 253 are at the same footing, and it is not different of powers, Your Lordship.
Thank you. Thank you.
That's this answer. Yes.
Let,
Much obliged, Your Lordship.
let me just ask, to taking it from there. When you're saying it is something not obligated, the Article 253 of the Constitution, in fact, it just deals with a very vital principle, and it also says about the India's international obligation. So how do you say that just because the Vienna, we are not a signatory and therefore this is permissible? Why do you say that? Because it starts with not only non-obstante clause, but it also says that Parliament has a power to make law for the whole or any part of territory for implementing any treaty, agreement, or convention. They're saying that you may do it, but not without also taking into consideration all these aspects.
Much obliged, Your Lordship. As you already stated, it may oblige with the international obligations, but the petitioners are contending that uh, the introduction of the full GAR provisions itself is invalid in the ground that it is the country is not binding the international obligations, whereas I have as stated earlier, I have proved that the country has introduced this GAR provision in line with the international obligations by quoting the Article 28A of the DTA, as well as the interpretation of various treaties, which I've already quoted in the first limb of my arguments, Your Lordship.
Thank you. Your colleague
Much
can
obliged, Your Lordship.
Your colleague can start.
It was
Thank you.
honor pleading before this court.
Greetings to the bench. Am I audible and visible, Your Lordships?
Yes, yes, very much.
Much obliged, Your Lordship. May I start? Thank
Please.
you, Lordship. If I may continue from where my co-counsel left, I'll be making two submissions. Firstly, that the provisions of GAR shall override the specific anti-provided provisions of DTA. And secondly, that S company is not eligible to claim benefits under DTA. Your Lordship, my first submission deals with four limbs. Firstly, Section 90 of Clause 2A is a law empowered under Article 246, which has the same powers as Article 253, that will be substantiated. Secondly, is a non-absent clause of Section 95 of the Income Tax Act. And thirdly, is the main and one of the important clause of India-Singapore DTA, which is Article 28. And fourthly, is a legislative intent of GAR, and the provisions of the VCLT shall also be interpreted. Lordship, coming to my first limb of the argument, Section 90 Clause 1 empowers the central government to enter into treaties with foreign government, firstly to grant relief, and secondly to prevent double taxation. Section 90 Clause 2 provides the option to the taxpayer to apply provision of the act or the treaty, whichever is beneficial to the SSE, which it states that the provision of the act shall apply to the extent to which it is beneficial to the SSC Lordship. However, with regards to provision Section 90 Clause 2A, the provision of the act shall shall apply to the SSC, even if such provisions are not beneficial to the taxpayer. The opening words being notwithstanding anything, and it being an non-obstant clause, the section 90 clause 2, the provisions of chapter 10A, which is GR, shall apply. Lordship, Section 90 Clause 1 was the law empowered under Article 253, which is substantiated by my co-counsel, but that cannot be called to be a supreme law. Section 90 Clause 2A was also a law got under the Parliament's power under Article 246. Lordship, if you could refer to Article 254, there's an explicit mention of whether the Parliament or the state will take over if there's any conflict between the two. But the same is not mentioned in Article 253, and it only says that there is a notwithstanding the provisions of this chapter, which has to be noted that it is only with respect to the division of power between the center and state that this article is brought into, and it is not a supreme power. Thus, it can be proved that Section 90 Clause 2A got under 246 also has the same footing with Article 253. Lordship, coming to the non-obstant clause of Section 95 of the income tax, Section 95 deals with a basic requirement for which it is applicable to an arrangement and not to the DTA for if it is declared as impermissible avoidance arrangement. This section begins with a non-obstant clause and thus has an overriding applicability to Section 90 Clause 2 itself. Your Lordship, if I could refer to you to the Kerala High Court in the case of Vodafone South Limited, which is a Union of India 2012 case, it held that the subsequent legislation cannot be controlled by the agreement. Lordship, departing from the maxim of that special law prevails over the general law, if your Lordship could refer to Section 100 of the Income Tax Act, it clearly talks about the applicability wherein the provision shall be applied to in addition to. Your Lordship, please notice in addition to or in lieu on the basis to determine the tax liability, Your Lordship. Lordship, coming to my third limb of the argument, which is the legislative intent of GAR. This intent was basically to curb the colorable devices and to prevent taxation through treaty shopping. In the landmark judgment of McDowell versus the commercial litigation, it was held that the tax planning is legitimate only if it is within the framework of law, which is not in the present case. That will be substantiated in my third submission, Your Lordship. Thus, the legislative intent is not to find that there is an existence of tax benefit. It is to ascertain the abusive manner used for the tax benefit, Your Lordship. That is the legislative intent behind GR. Also, Your Lordship, the provisions of LOB is not wide enough to address the whole of the tax avoidance within two contracting state, and thus the GR being an anti-avoidance provision is prevails over the treaty to make sure that the object of the treaty and the purpose and there's no abuse of the treaty, Your Lordship. Lordship, as already stated by my co-counsel as being one of the important clause in India-Singapore DTA, which is Article 28A, which of course the article was got through a mere consent and agreement between both the contracting state, which stated that the domestic legislation can prevail if at all there's any need for if there's any tax avoidance or tax evasion in the present case, Your Lordship. And that's why in this present case, the GR has been is overriding the power special anti-avoidance provision, and it cannot be called that there is a unilateral domestic legislation, because there's an agreement already. There's an article already in the agreement, Lordship, which makes it very clear that GR is applicable even if there is an anti-avoidance provision already present here, Lordship. Coming to the interpretation of VCLT, the principles of pacta servanda, which is Article 22, and the general rules of interpretation are needed to form a basis of treaty interpretation. Your Lordship, Article 31, Clause 3 of the VCLT states that a subsequent agreement or a practice which establishes the agreement shall be taken into for the interpretation of the treaties. My argument pursuant to this article is that the treaty should adopt such a safeguard clause to make sure that there is no tax evasion and to prevent abuse of the treaty, Your Lordship. That sums up with my second submissions, such that the GR will prevail over the SCR. Lordship, if you're satisfied with my second submissions, the council will move on to the third submission as to S company is not eligible to claim a benefit under the TTA. Lordship, coming to my first limb of my argument is that LOB clause is under Article 28 LOB clause under Article 20 in the India-Singapore TTA has not been met with. Even if it is so, it is not sufficient to prove to get tax benefit, Your Lordship. Secondly, a valid TRC certificate is again not sufficient, and Article 4 of the India-Singapore DTA clearly talks about the residency which shall be substantiated henceforth. Lordship, also the grandfathering benefits in this present case shall not be applicable, and fourthly is that satisfying all these points, it can be clearly proved that there is no commercial substance in the present case, and the four tainted elements of the of IAA, the impermissible avoidance arrangement, shall be proved. Lordship, coming to my first limb, that Article 4 of the India-Singapore DTAA, it states that the resident of the contracting state means resident in accordance with the domestic tax law. In the present case, it's the Singapore tax law, which states that the resident of Singapore in relation to the companies where the control and the management of the business is exercised. Lordship, if you could refer to para 5 of the Moot proposition, it clearly states that for the purchase of shares, the F company had conducted negotiations and discussions with U company and not with the S company by itself. This clearly proves that the ultimate and the control and management of the day-to-day affairs by itself is controlled by U company, and thereby the residency under Article 4 is not proved in the present case, Your Lordship. Lordship, under Section 90 Clause 4 of the Income Tax Act, which makes TRC certificate a precondition to get a tax benefit, in the case of Union of India versus Azadi Andolan case, it was clearly stated a mere tax residency certificate is not sufficient and additional documents are to be made. As already proved in Article 4 that the TRC that the residency is not being proved. Thus, there is a huge doubt on the validity of TRC by itself. And even if it is so valid, it cannot be sufficient to prove the tax benefit, Your Lordship. Lordship, coming to my second limb of my argument, which is on LOB clause. So the LOB clause under Section 24 of the India-Singapore DTA has two limbs. Firstly, the subjective test, and second is the objective. Subjective is where the primary purpose itself is a tax benefit provided under the India-Singapore Treaty. And the objective test is to prove that S company was a shell company which shall be dealt henceforth. Lordship, coming to the subjective test, there was an erstwhile structure that was crucially made for the purpose of tax relief. If a Lordship could refer to para 2 of the Moot proposition, it clearly states that U company incorporated a subsidiary N company, and immediately on incorporation, the N company acquired shares in Indian company. This itself proves that there is a structure that is pre-planned and already made to avail the capital gain exemption and to avail the tax benefit, Your Lordship. Also coming to the objective test, the S company, as according to the Article 24 Clause A, it is to prove that S company's business had nil and neg. Your Lordship, my time is up. Can I please take 2 minutes to sum up my arguments, Your Lordship? Thank you, Lordship. Lordship, in the objective test in Article 24 clearly states that S company's business is nil and negligible. That is to prove that the annual expenditure preceding the date of capital gains, that is preceding 24 months from the date of capital gains, it should be more than 2 lakh Singapore dollars, Your Lordship. But Your Lordship, if you could refer to para 6, it clearly states that it is only during the year of sale that they have incurred an expenditure more than 3 lakh Singapore dollars. But the 24A talks about the 24A article talks about preceding 24 months from the year of sale. So there are no additional documents filed on the expenditure that was made in the preceding years, Your Lordship. Also, Lordship, Article 13 Clause 4 of the DTA states that the alienation of shares, gains from the alienation of shares acquired before 1st April 2017 can only be done in the alienator's residence, which in the present case is Singapore. But it is to be noted here in the para 5, Your Lordship, F company deposited the amount in US bank account and not in Singapore by itself. That's the main point to note, Your Lordship, because according to Section 10 of the Singapore Act, income is taxable on receipt basis, but there was no amount that was remitted inside Singapore for them to prove, for them to get the tax benefit or to get the capital gains transaction. In the case of DCIT versus International Asia Limited, though the provisions of 13 Clause 4 allow exemption Article 24 clause A is a restriction to that exemption, Your Lordship, and thus since there is no remittance inside Singapore, the capital exemption cannot be claimed here, Your Lordship. Lordship, from the above arguments, it can be proved that the arrangement was made ultimately for the tax benefit and that there was no commercial substance in any step of the arrangement, or not by the arrangement. Each and every step from the restructuring till the selling of shares, there was no commercial substance present in part of the arrangement, Your Lordship. Also coming to the grandfathering of shares, Your Lordship, Rule 2 clause U, which is an amendment that came up recently in 2017 in the circular of 7/17, it stated that the provisions of Chapter 10A, which is GR, shall be applicable to any arrangement irrespective of the date. It has amended the 10 clause U 1 clause D, which stated that it shall be only after 2018. But there was a recent amendment which came up saying that it shall be applicable at any point where the investment has been made, Your Lordship. Your Lordship, finally coming to section 96 to prove impermissible avoidance arrangement, the four tainted elements that the tax benefit, arm length price, misuse of the act, and the bona fide and the lack of commercial substance was proved throughout my arguments with reference to the fact sheet and with reference to the sections of the income tax. Your Lordship, it is to prove that every arrangement was made to evade tax through a colorable device, and the rights and the obligations of the parties are not created within the arm length price, Your Lordship, and there was a clear planning of restructuring that was taken place to avail the treaty benefits to satisfying the four elements of the IAA. Thus, Your Lordship, from the above arguments, it's clearly proved that S company cannot get the tax benefit and the claim exemption under Article 13 clause 4, Your Lordship. That sums up my argument, Your Lordship. Your Lordship, is there any questions, Your Lordship?
Brother Justice Valmiki, would you like to?
Your Lordship, you're not audible. Your
I wanted some clarity on the findings of the AO on the arrangement itself. Assuming that the virus the challenge to the virus fails, how do you sustain the AO's order when or at least hear the argument on the findings of the AO on the arrangement itself, specifically in relation to the double taxation avoidance agreement with Singapore in relation to the treaty. I'm not talking in relation to Indian law, I'm talking of to the treaty itself.
Your Lordship, if you could refer to section 144BA, it clearly states that before making an arrangement, an impermissible avoidance arrangement, a clear there's a lot of investigation that goes into before declaring and giving the assessment order. Firstly, is that if the assessing officer feels that there is a lack of commercial substance, he first takes it to the principal, the commissioner, and the commissioner would ask for objections to be framed, and only after the objections and the additional documents that are framed, and only after that, if the commissioner is not satisfied with the objections framed, will the order of IA will be passed, Your Lordship. Lordship, if you could refer to the assessing officer's order itself, it clearly states that after taking all the requisite approvals and the Singapore company has been given an opportunity to hear opportunity of being heard, Your Lordship. After satisfying all the procedural requirements, only after that the order was passed, Your Lordship. If that answers to your question, Your Lordship.
Thank you. Thank you.
Thank you, Your Lordship.
But just like to ask one thing.
Yes.
Since we also talk of the directive principle of the state policies, particularly Article 51, which says this promotes the international peace and security, and the state shall endeavor to foster the respect for international law and treaty obligations in dealing with the organized people with one another, etc. What would you say that how would this directive principle of the state policy to be applied, while interpreting or while appreciating this version of yours?
Your Lordship, one main thing is that the directive principles of state policy the ultimate purpose is to make sure that there is no abuse of the treaty. So the state at all places should take the effort to make sure that the tax evasion is not done through any colorable devices. Being this treaty being between two countries, which deals with international law as well, the state takes immense effort to make sure that there is no colorable or dubious method used for tax evasion, Your Lordship. That's why the state has taken Article 153 to foster respect over the international law, Your Lordship.
Thank you.
Thank you, Your Lordship. If that answers to your question, it was an honor to. Lordship, can I please do my prayer before that, Your Lordship?
Yes, please.
Thank you, Lordship. Wherefore, in the light of the issues raised, arguments advanced and authorities cited, it is most humbly prayed before this honorable court to dismiss the writ petition filed by the petitioners as devoid of any merits, and to pass any other order as this honorable court deems fit and proper in the circumstance of the given case and the interests of justice, equity, and good conscience. And for the act of kindness and justice, the counsel for the respondent shall be duty bound and forever pay, all of which is most humbly and respectfully submitted. It was an honor to plead before this honorable court, Your Lordship. Thank you.
Thank you.
Lordship, if I now permit, may I begin with my rebuttal?
Please do.
Thank you, Lordship. Your Lordship, firstly, the Council would like to humbly reiterate that in the judgment of Director of Income Tax versus New Sky Satellite, it was observed that the provisions of the Vienna Convention on the Laws and Treaties were universally accepted as a part of the customary international law, and that India is using that as a guiding principle in its dealings. Further, Your Lordship, I would like to point out that the learned counsel for the respondent has argued that the OECD model convention also is saying that unilateral anti-avoidance is allowed. Your Lordship, India has not ratified OECD model convention and is not a signatory to that. Further, Your Honor, the learned counsel for the respondents argued that UCO's parent, the UCO, which is the parent, negotiated on behalf of the ESCO, and thus there is a case of beneficial ownership and somebody else is the actual actor behind the company. Lordship, the council fails to understand that how is it wrong to consult and take guidance from a parent in good faith if the Singapore entity feels so. Lordship, if a child's parent is involved in any discussions related to him, it is in good faith and not any otherwise. Your Honors, the council sees no wrong in consulting someone in whom a person poses his confidence. Just negotiating does not in any way undermine the independent corporate character of the petitioners, Your Honor, for this purpose. Further, Your Lordship, it is not illegal to have a bank account in any other parts of the world. Many companies have their bank accounts in the other country. How does the respondent argue that having an account in the other country is illegal, or is an indication of some other person controlling it? Moreover, Your Lordship, there is no capital gains tax in Singapore, and therefore the argument which was posed by the learned opposing counsel that the receipt of income is not in Singapore is not relevant, as there is no capital gains tax over there. Further, the learned counsel also mentioned about the circular. Your Lordship, the circular they are referring to is the circular number 7 of 2017, which was released in January 2017. But Your Honor, this circular is just a guidance for the department and the AO and is not binding on the assessee and not binding on this court. Further, Your Lordship, I ask my learned counsel for the respondent, should the AO, who has been given a wide executive discretion, be allowed to step into the shoes of a company and decide what is commercially viable or not before every transaction? If yes, then how does the council on the other side justify such executive discretion for hundreds and thousands of transactions that happen every day, Your Lordship? If everyone started uh, taking the approval and started thinking about this wide, broad power of whether a GAR may be applicable or not, then, Your Lordship, I don't know how many years it will take to complete the transactions itself, Your Lordship. And if it were to be allowed, Your Honors, this will be a huge blunder from an economic, commercial, and policy point of view. Further, Your Lordship, the Council also mentioned about 28A, Article 28 of the Singapore Treaty. Your Lordship, the petitioner is a tax resident of Singapore, as shown by the valid TRC. And the moot point here is whether the GAR provisions are constitutional or not, and not whether there is an understanding in the treaty for allowing it or not. Your Lordship, the constitutionality is an issue which is mutually exclusive from whatever has been signed in the treaty. Constitutionality is an issue internal to India and is unaffected by any such articles which may be in the treaty. Further, Your Lordship, the law is constitutional or not is a separate issue, and understanding between two states on whether each of them can make such laws. Your Lordship, if the petitioner may just have 1 minute to sum up his rebuttal, as the time is up. Obliged, sir. Your Honor, according to Section 95, the provisions apply notwithstanding anything contained in the Act, and thus they override the relevant provision of the Act. I would like to ask the opposing counsel, how is this non obstante valid in the first place? By saying that it overrides everything in the Act, can this provision override the charging provision? Can it override the scope? Can it override the definition of resident? Can it override Section 4, 5, 6 of the Act also? Lordship, if they contend that it overrides the charging provision, then this is unfounded. It appears that the non obstante has just been enacted without much thought and thinking. Further, Your Lordship, the council mentioned that we, being a foreign company, cannot invoke the constitutionality as the GAR is, but Your Lordship, the GAR is made applicable to both domestic and international transactions. The scope of GAR is not limited to just domestic transactions. And since remedy under Article 14 is available to non-citizens also, we can challenge the constitutionality as we are being directly affected by these GAR provisions. Further, Your Lordship, in the written submission of the respondents have mentioned a case of Scaps Industries, but Your Lordship, this is not relevant for the issue as it deals with the issue of not having a TRC is no bar claim the treaty. Thank you, Your Lordship.
Why do you emphasize as to the GAR violating the rule of law? Is it not permissible for the state to make the domestic law? Is it not when it finds that there is an avoidance of the tax, it can also look into the same?
Indeed, a very pertinent question, Your Honor. But the main problem with the GAR provision is that it is not laying down the strict rules and in what cases it would be applicable. For example, the principal commissioner has been given power to declare any transaction as impermissible avoidance arrangement. And according to Section 96 fourth condition, it has provided that if he founds that a transaction has not been entered in a bona fide intention, then he can invoke it. But the Act nowhere defines that what a bona fide transaction is. If such also my co-counsel mentioned that if it is allowed that a AO can step in the shoes of the company just to determine the a bona fide just to determine the intention of the company, then how will it work as there are thousands of companies, thousands of transactions taking place? Also, the arbitrariness and the discretion which is provided for any democratic country which functions on the rule of law principle, it is not viable that such a miscarriage of justice can be done. Because if a if a company, also the my learned counsel for the respondent mentions that there has been provisions for the approving panel, but I like to say that it is also executive discretion only. When the government is only forming, it is the principal commissioner is appointed by the government and government is only forming that panel. So the discretion which is provided to them is executive discretion, which is bad in the eye of law. If it answers your question, Your Honor.
Yes, your partner needed to say something. No. All right. Yes, brother.
I think I'm good. Thanks.
Okay.
They seem to have answered exactly what
Yes.
you've asked them. Thanks.
All right.
Your Lordship,
That
can I
is
take a minute to do my sir rebuttals, Your Lordship?
yes.
Yes, Lordship. Lordship, firstly, referring to the case of Cosmo Tours and Travels versus Union of India, the incorporated entities tried invoking Article 14 to get the rights under Article 19. This primarily means that the companies tried to use Article 14 as a means to enforce the rights under Article 19 of the Constitution. This attempt has been criticized by the courts, leading to the dismissal of several petitions seeking to do the same, Your Lordship. Lordship, also answering to the other rebuttals posted by my opponent counsel on the as the parent, is it okay to get a negotiation from parent company? company. Lordship, it has been noted that the parent company, they are the main beneficial owner of the whole structure, Your Lordship, and that is why the negotiations and discussions are gone with the U company. Also, it is to be noted, if they have if it is okay to do negotiation, why is the S company's bank account is in US, Your Lordship? That is a point that is to be noted here, where if there was no control over the management of their business, then why is the bank account in US? Your Lordship's answering to the next rebuttal is that OSTD convention is just a guiding principle that was used to reiterate the argument, Your Lordship. Also, coming to the circular that was stated by my opponent counsel, the arguments of circular is made for the pervasive value, and that it is a part of delegated legislation that is within the purview of the parent act only, Your Lordship, as the whole circular was all about the implementation of GAR. Your Lordship, also the validity, Article 4 of the India-Singapore DTA was contested here because the reason as to why we say a TRC is not sufficient is to prove that there are certain cases like this happened in the present case under Article 4, where the residency is not proved, and that is why the council states that a valid TRC will not be sufficient. Also, Lordship, in the case of Azadi Andolan, Union of India versus Azadi Andolan, it was clearly stated a mere submission of TRC shall not be valid. Also, Lordship, coming to the non-abstent clause, the council would like to state here that in case of any conflict between two non-abstent clauses, then the courts can apply the doctrine of harmonious construction to prove which article shall prevail for giving the justice and conscience, Your Lordship. Also, regarding the last point that I would like to reiterate is the tax evasion, Lordship. The GR is not applicable to all the tax evasions, but only the tax evasions which has been done through a colorable legislation, with a dubious method, and to abuse the treaty. Only in such cases the GR will be applied, and not all the cases with respect to that, Your Lordship. If that answers to the my opponent's counsel's question. Thank you, Your Lordship. It is an honor to plead before this honorable court.
Whether Justice Valmiki will have any question? Brother Justice Valmiki, are you there?
I can hear you. I think there was a slight break in the
Okay.
signal.
Any question on your side?
No, I think I'm good. I'm done. Thanks.
All right. In that case, believe that like to just go to the breakout room.
Yeah.
Yes, Your Ladyship, we'll send it.
Thank you, Your Lordship.
Thank you. Thank you,
Lordship, it
everybody.
was
you,
an
Your
honor
Lordship.
Thank you.
speaking
Your Honor.
before this.
Thank
It was
you.
an honor
Thanks.
arguing before this court.
Is the organizer creating the breakout room?
Your Ladyship, you will receive a notification on your screen of to join the breakout room. You'll have to click to join.
Yes. Presently, I don't have that on that breakout room.
Mooters exemplify these words when they display the courage and initiative to speak up against injustice. All the participants of this competition have been assertive in their demeanor and diligent with their arguments. This competition has stood witness to extremely challenging rounds. All in all, this competition can be termed as a huge success. Behind every success story are people that make it possible, and it is befitting to recount their contributions and recognize them for the value that they've added to our competition. None of this would have been possible without the Vice Chancellor of Maharashtra National Law University, Mumbai, Professor Dr. Dilip Uke, and the Registrar of Maharashtra National Law University, Mumbai, Professor Dr. Anil G. Varyat. Further, we would like to thank the chairman of AIFTP, Mr. Mitish Modi, whose contribution has been invaluable. I call upon him to grace our occasion with his kind words.
Will I start?
Yes, sir.
So there is some network problem. Good afternoon. Good afternoon to everybody. Warm welcome to our respected Honorable Justice Sonia Gokani Madam, the chief guest of this valedictory function. Honorable Justice Valmiki, the guest of honor of this valedictory function of Padma Vibhushan and a Palkhivala Memorial Moot Court Competition 2022 and Research Paper Competition 2022. I also welcome other joint organizations, the President of ITAT Bar Association, Mumbai, Advocate Vipul Joshi, Advocate Sunil Khuslani ji, the President of GSTPM, the National President of All India Federation of Tax Practitioners, DK Gandhi ji, Senior Advocate Dr. K. Shivram ji, other from the MNLU University, respected Registrar Dr. Uike, and the Vice Chancellor Mr. Anil Varaya sir, and all other dignitaries who have joined in this very important flagship program for All India Federation of Tax Practitioners. Since last 2 months, this is the hard work of all the organizations and more notice from the Law University. And since last 4 days, 24, 25, 26, and 27, we have successfully completed this flagship program competition for the encouragement and the development of the youth in the law fraternity. I welcome all of you in this wonderful valedictory function of Moot Court competition. As the chairman of the Western Zone, I acknowledge the support and the contribution by in the preliminary round as judges. I also acknowledge the support and the contribution made by the honorable members of the ITAT from Mumbai benches and the Surat bench. We acknowledge the presence of the ITAT president, G.S. Pannu, as the chief guest at the inaugural ceremony, and Justice Suhas Vimane from Maharashtra State Sales Tax Tribunal. We acknowledge this infrastructure provided by Maharashtra National Law University and support to make this program as a very successful and memorable one. The active participation of the students robes the hope of their bright future in law faculties. They will surely be part of the nation building, and they have tried their level best to represent the cases in the preliminary rounds, in semi-finals, and today in finals and result. I, on behalf of West Zone and on behalf of the All India Federation of Tax Practitioners, congratulate all the students and participants, all the preliminary judges for their support, and I hope that our endeavor will continue in future also, because we have started in 2003 to 2013 in physical format. From the last year, we have started this program, this competition on virtual platform. This is the second year, and this time the support from the university and the interest of the students, which shows that in future we will continue this competition program. And hoping this, I once again welcome all of you, congratulate all of you for this wonderful competition program in the memory of N.A. Palkhivala, and give my best wishes to all the students in future. Thank you very much.
Thank you so much, sir. We are honored to have with us the president of the ITAT Bar Association, Mr. Vipul Joshi, who has been a guiding force throughout this competition. I call upon him to address the gathering.
Yes, our chief guest for the valedictory ceremony, Honorable Justice Srimati Sonia Gokaniji, Judge Gujarat High Court. Our guest of honor, Honorable Justice Valmiki Menendez, Judge Bombay High Court. My fellow heads of institutions, Dr. D.K. Gandhi, President of AIFTP, Sunil Kupchandaniji, President of GSTPM, Amitesh Modi, Chairman West Zone of AIFTP, Mr. Rao, IPP of AIFTP, Dr. K. Shivram, who has been our past president as well as past president of the AIFTP, my fellow professionals, participants from various colleges across India, ladies and gentlemen. I extend you all a very relaxed afternoon after grilling and tense final round of the Moot. One of the golden rules which my senior had advised me was, after a case is over, to come up the courtroom, leaving the matter there and there only. Initially, I could not realize the importance of this simple rule, found it to be too simplistic and rather preachy, having not much practical value. But after years of practice before the court, I realized how golden is this rule, so immensely practical. You see, the rule means if the matter has gone bad, don't feel complacent. For tomorrow, for another matter, you will have to start afresh. If the matter has gone not good, then don't feel dejected. For tomorrow, for another matter, you will get a chance to start afresh. But believe me, this so simple looking rule is an immensely useful rule for a day-to-day litigation practice. So, this applies also to all the participating teams, including the two teams awaiting the decision, especially when all your cases, the decisions were always, so to say, split one. All teams displayed awesome enthusiasm, skill, and determination. You all deserve a medal for such a spirited participation, for that, after all, count for such a moot court competition. The principle of a moot, the purpose and principle of a moot is not to judge who had better knowledge, but to be, but not about the topic, but for all you have, use the law because for all the law students and all the participants, you had equal opportunity to access the material available and plenty resources. The purpose was to give first-hand experience about how to transform that knowledge into actual practice, where your knowledge merely may not be found enough. Your skill, your presence of mind, your attitude all count sometime more. And since this competition, it is a memory of late Mr. Mani Palkhivala. As I mentioned in my earlier welcome speech, Mr. Nani Palkhivala was a legend and a godlike figure in the court. Though he was forceful and articulate, but was never intimidating or overbearing to the court, at the end he was always courteous and graceful to all. I think these are the qualities which are more important to be imbibed by the participants. And why can you get such a better platform to learn all these tricks of the trade, what to get skill, court craft, than this moot court, where you had a chance to argue before the real eminent judges of high courts, members of ITAT, and senior professionals in the virtual courtroom, which virtual hearings may perhaps become a norm in days to come, with everything becoming virtual in India. While we are all eagerly awaiting the pulse of wisdom from our chief guest and the guest of honor about the moot, let me read one portion of Mr. Palkhiwala's book, We the People, in which he very clearly mentioned what should be the role of a good a good judge, a good advocate, and what he meant by the court. I read from his book, We the People, page number 351, quote, according to Mahatma Gandhi, a true lawyer is one who puts truth and service in the first place. In his autobiography, the Mahatma observes that the law is not an intellectual algorithm to make black appear white and white appear black, but it is a ceaseless endeavor to enthrone justice. These words well represent the ideal of excellence in law. Without the law, the crown would always go to the loudest voices, the biggest sticks, and the readiest fist. Redressing wrong is in many religions an attribute of the divine, and the law serves one of the greatest social purposes when it dethrones wrong. It is this aspect of the law which made a thinker observe that God is more palpably present in a court of justice than monastery. Such a good pulse of wisdom coming from uh, since the Moot is organized in the memory of Palkhivala, as I stated, I must mention that he was a past president of a association of ITT Bar Association, and uh, he was a stunned supporter of not only the fearlessness but the freedom of justice, equity, and fair play. So I I wish all the participants so that they can strive to imbibe this very important aspect in your litigation practice. I wish all the participants the very best for the future litigation, for the future legal practice. And of course, simple words of thanks will not be enough. The excellent teamwork shown by the core team of the participating organizations, and more particularly, the Moot Court Society of Maharashtra National Law University, Mumbai, fondly called as Team MNLU, which has done excellent work and arrangements. Thank you very much.
Thank you so much, sir. We're also pleased to have with us the National President of AIFTP, Mr. D.K. Gandhi. I call upon him to grace us with his kind words.
Not there. The process.
I believe that he's having some connectivity issues. We are pleased to have with us Mr. Sushil Kushlani, the President of GST PAN. Sir, would you be kind enough to address the gathering?
Unmute key.
Respected guest of honor, Honorable Justice Valmiki Manages, Bombay High Court, Dr. Dilip K, Vice Chancellor, MNLU, Dr. Anil Varyar, Registrar, MNLU, Mr. Mitish Modi, Chairman, AIFTP West Zone, Advocate Vipul Joshi, President, ITIT Bar, Senior Advocate Dr. Shriram, all office bearers and managed committee members of the participating organization and participating advocates and delegates. A very good afternoon to you all. On behalf of JSTPM, I would like to thank Chief Guest and Guest of Honor for accepting our invitation and gracing the event. 12th Padma Vibhushan NA Palkhivala Moot Court competition was a great success and tribute to the legendary advocate Nani Palkhivala. It is a great event. I would like to recognize the efforts taken by Mr. Amana Khare, Mr. Paras Savla, and hosts and co-hosts of the MNLU under the able guidance of Dr. Dilip Uke, Vice Chancellor, and Dr. Anil Varyat, Registrar of MNLU. The event wouldn't have been successful without the guidance of our senior advocate, Dr. K. Shriram. I would like to thank all the honorable judges. In spite of their busy schedule, and Sunday they attended the program and graced the occasion. And of course, participants of competition all will agree with me and appreciate the level of knowledge they have. Hats off to them. I wish them all success and best of luck. Thank you very much.
Thank you so much, sir. We're elated to have with us Senior Advocate Dr. K. Shivaram to deliver his address.
Thank you very much. My Lord Justice Srimati Sonia Bakani, my Lord Justice Sri Valmiki Banerjee, and Mr. Vipul Joshi, President of the ITD Bar, and Sri Sunil Kutlani, President GSTM, and Mr. Modi, Chairman VHO, and our professionals, brothers, sisters, and the law students. Friends, at the inaugural session, our President of the ITATC, GS Pannu, gave the tips to how to become a good tax practitioner. In fact, let me share the two more practical tips to the law students. One could be, like at least in Mumbai, of course Gujarat also, we are having the regular tax bench. At present, it is headed by Honorable Justice Sri Dheeraj Singh Thakur and Honorable Justice Sri Valmiki Banerjee, who was here morning in the judging the students. And in fact, you know that the law students, if really they want to learn the tax litigation, they must visit the tax bench and sit there at least for 1 week, at least 1 week. So much to learn when the judges put the question to you and how the counsels will argue. And this is the what I feel. Instead of sitting at chamber, we're able to come and sit in the court at least few days. That will be best learning. I don't even get anywhere else is concerned. That is the second. And yesterday, in fact, that we have celebrated the Constitutional Day. And when we celebrate Constitution Day, in fact, our Prime Minister and Honorable Chief Justice and our President of India, everybody talking about the Constitution. Therefore, my appeal will be that all the law students, they really want to excel in their practice, they should study the constitutional law. And if they're able to study the constitutional law, any other law, income tax or GST, becomes very, very simple. I don't think if master the constitutional law, automatically you're able to argue any good matter on the taxation law is concerned. Now this time the research paper is judged by the Honorable Justice R.V. Ishwar. And in fact, I thought of just quoting a few lines what we wrote. I am happy to say that the standard of the research papers was high and the participants have done exceedingly well. Generally, I wish them all the bright career, warm wishes. In fact, that shows that how the research paper has been done. But today, when we saw the competition, all the two teams have done excellent work, and I think they also deserve the much more appreciation from the party, from the all of us. Now, only thing is that as the organizer, Mr. Joshi mentioned that I was in fact, we are organizing this in so many years. Let me share with you that every year we try to improve, bring some innovation. In fact, we wanted some guidance from the Honorable Judge present here, how we can improve further is concerned. So, of course, what we can do is that, in fact, what we are missing from the physical moot court competition and virtual, we are not able to interact with the law students. That is the one part which we are missing over here. So we are not able to get any feedback from the law students, whether is it we are doing correctly or you're not able to do. So what we can try, what my request to the organizer is concerned, you may prepare a small sheet or something. You can send it to all those law students who have participated, can get some feedback from them. So that may try to help us, when we prepare the next year, how best we can do or we can improve on this aspect is concerned. Now, finally, what we can also consider, like whether is it possible to have when military sanction instead of lecture, can have some panel of some senior advocate, they can some of the law students can ask some question to them so that they may able some doubt on the real practice is concerned or something on that if they're able to get it, that will be real service to the law students are concerned. In fact, we are grateful to the honorable judges who spared their valuable time today, in spite of being Sunday morning up to 10 up to 1 o'clock. It is in fact we are very much obliged to them. And we have started this moot court competition somewhere in August. It took nearly 4 months for us, and it is how we have done it. And apart from the office bearers, Mr. Modi mentioned it, and Mr. Kustalani also mentioned it, that others who are really deserves for this. That is our Honorable Justice R.V. Ishwar, who has judged our research paper. Tushar Emani, senior advocate from Gujarat, who has judged the research paper written by the law students, and our Dr. M.K. Murthy, Mr. Manish Shah. Everybody helped us. Vinay Patkar, Gopal, Ajay Singh, Neeraj Sheth, Paras Saula, Rahul Akani, Rashi Bekal, Divyesh Chawla, Ashwin Acharya, and Vinod Maske, and many, many more. With this, thank you very much for giving me this opportunity. All the best. Good luck. Thank you.
Thank you so much, sir. We're pleased to have with us the Honorable Justice Valmiki Menzes of the Bombay High Court. He's also taken our time from his busy schedule to judge the finals as well as grace our occasion as the guest of honor. We're extremely grateful, sir. I request you to grace us with your judicious words.
Thank you. Um, First of all, I mean, I'm not aware of all the names of the organizers, but it's indeed a privilege for me to be part of the whole process of judging this moot court. Of course, a greater privilege sitting with Justice Sonia Gokhani from the Gujarat High Court, and uh, many of the faces that I see are familiar here who appear in court. Mr. Dr. Shivaram and some of the others that I see the names there, may not see their faces, but you know, I have judged moot courts, physical moot courts. This is my first time on a online moot court. Uh, the of course the physical moot court has its advantages of having the interaction directly with the students, as Mr. Shivram says. That's probably what is missing here, and I appreciate his request for feedback from them. But the moot courts that I've judged, just to share the experience, have been on topics which are of more general nature. Uh, this was not only a specialized topic of income tax, or rather, tax topic, but to sort of borrow from doctor's language, this was almost an area of super specialization, a cross between constitutional law, challenge to the virus of a provision of the Income Tax Act, private international law, where tax agreements, international tax agreements, come into play, and the provisions of the IT Act. So, I mean, all in all, I think this is something that's been of a great experience to me, and being part of this. Um, so, I mean, thanks to the organizers for having us to be part of this endeavor. um, uh, it really needs to be said of the organizers to put together such a huge moot court in terms of the number of participants. I'm simply amazed at this, because using this platform has really, I think, brought a huge number of students, sort of uh, into interaction with many of the stalwarts in the legal profession that I see out there. Um, while saying that, I would also, I mean, I this doesn't actually should not come across as criticism, just a small critique on the approach of the participants in the moot court. Um, your delivery was fantastic. I mean, the research, the way you all addressed the topic, the way you answered our questions, our queries, it was really wonderful. You kept your calm. You've obviously, delved deep into the subject. But just taking a sort of a leaf from what Dr. Shivaram said earlier on. Um, at the end of a moot court is basically a mock court. You need to be more real in how you put across your case. You need to be more real in terms of what really happens in court. Um, like I said, I don't want to sound critical about this, but I would like you all to endeavor a little harder in presenting, like in this particular case, more about the Vienna Convention. How, as India is not a signatory to the convention, what do we borrow from the convention in terms of interpretation of these treaties, even though we are not signatories to the Vienna Convention. A little more, delve a little deeper into how a challenge is thrown to a virus of a statute in terms of the sources of the power, how Parliament has enacted two different provisions, one empowering the government to enter into treaties, and the other where it has directly enacted Chapter 10A. So these two provisions juxtaposed against each other, and the powers of Parliament, because ultimately you're throwing a challenge to the virus. So I thought one could go slightly deeper into that area, because that seemed to be the main sort of thrust of both sides' arguments. But please don't take it as a criticism in a negative sense. It's just to sort of improve things. And yes, I mean, the I would expect you all to be more in court, as the senior counsel said, because that I'm sure would contribute to improving your standards, not only in moot court, but prepare you as future lawyers. I really look forward to seeing, if not most of you in our courtrooms very soon. Uh, Thanks to the organizers. Thanks for having me here. It was a real great pleasure. Thank you.
Thank you so much, sir. We're honored to have Honorable Justice Sonia Gokhani of Gujarat High Court, who judged the finals along with Justice Valmiki Menzies and is here as our chief guest. Thank you, ma'am. I request you to address the gathering.
Thank you very much. My esteemed brother, Justice Valmik Menzies, respected dignitaries, organizers, and dear delegate students. Let me congratulate in advance the winner team and the team which could not talk but whose spirited performance made this final extremely interesting and brought an element of excitement, as would happen in cricket matches for both of us. My brother would surely agree to that. Uh, these events are for the participants to imbibe the lessons that what is vital is the best performance as a culmination of systematic and intelligent preparedness. All other teams which participated earlier also deserve equal appreciation for the very reasons. As Srimad Bhagavad Gita says, Abhyasena tu Kaunteya, continuous studies and tireless efforts. That is the only thing that one will need to take as a desired goal. It is indeed a matter of immense joy to be present in this final round as my heartiest tribute to the legend of this nation, without whose reference possibly the no tax event could ever be concluded. This valedictory session of 12th Padma Vibhushan and Palkhivala Memorial National Virtual Moot Court Competition and Research Paper Competition. I am so happy to be a part of this. Before, in fact, I had thought of entering the legal profession. His books were my companions from the library of my father, who was an ardent admirer of the legendship Palkhivala. In his lecture on the ideology of taxation, the fiscal stimulus, he said, dividing the same into three basic considerations: to raise the revenue, to bring about certain economic and social results, and to discourage the consumption and use of articles which state regards as obnoxious. I quote, he says, most taxes fulfill the first consideration. The second objective is achieved by taxes like income tax, wealth tax, and estate duty, which try to reduce disparity between wealth and the poverty. The third viewpoint is served by taxes like those on liquor, tobacco, and gambling, Napoleon regarded vices as very good patriots, and Emerson endorsed this view to add that tobacco can cheerfully carry the Lord of Armies. Iron quote. Adam Smith, in his book Wealth of Nation in the 18th century, said that there are four objectives. First, the equity, equitable and fair taxes between the different persons. He also says that I have the great hopes in the young people, young man and woman. To the youth of this country, I would like to make an earnest appeal to enter public life and would comment. For this consideration, he gave three maxims. One, you must not desert the ship because you cannot control the winds. Two, it is better to try to do something and fail rather than try to do nothing and succeed. And three, for the rebirth of morality in Indian politics, the period of gestation will prove lengthy and the delivery promises to be painful. But you cannot dedicate your life to a greater cause. I would say that this noble profession of law longs for incessant hard work, unstoppable zeal to learn, unquestionable honesty, and selfless service from those who wish to join. The technological advancements have proved to be borne, and to keep pace with the same, an extra mile needs to be walked, with every process of assessment becoming faceless and on E mode for the purpose of neutrality and transparency. Matching standards of robust integrity would need to be met by human endeavors alone. The limitless informations and details are at the fingertips of each one, but what needs to be addressed individually is turning this into the knowledge and then into the wisdom. Human ingenuity with dedicated convictions can assure surely that. I would here join Dr. Shivram, who has referred to the learning from the attending to the courtroom. I would say that the live streaming, which is in the case of Swapnil Tripathi, which has been authored by our Honorable the Chief Justice of India, which essentially drives to this point to enable the students to learn. It is so heartening that many of the high courts have already started, and on some of the occasions, the Supreme Court also has started the live streaming. It is one very, very beautiful way of learning of the students. But this online moot also makes it feasible for saving the time, energy, resources, and it also makes it feasible for many of us to join. So therefore, this endeavor also is quite appreciable, and I would still second both Dr. Shivram and my brother Justice Palmiki Menzies, that what you experience and what you gain from an actual court working or the court working, seeing it is always very beautiful and very exciting. So I think that also can be done, but at the same time, this endeavor is quite appreciable. Feel that for the students, I would say that more than these hard skills, also the possessed and acquired both the soft skills of coordinating with the colleagues, the mannerism while dealing with one and all, and positive attitude of learning and aptitude of serving, perseverance and being helpful to others would make one an asset in whichever institution one may go. Would really wish each one of you to achieve the greatest height in the profession, and my sincere thanks to the organizers for this opportunity to be with you all and allow a new learning in the process. My special thanks to the Maharashtra National Law University, All India Federation of Tax Practitioners, ITAT Bar Association Mumbai and Surat, the GST Association of Maharashtra, and all. Would end with the prayer Sarve Bhavantu Sukhinah, Sarve Santu Niramaya, Sarve Bhadrani Pashyantu, Ma Kashit, Ma Bhavet. Thank you so much.
Thank you so much, ma'am. That marks the end of today's addresses. We will now proceed with the declaration of awards. We will start today's award ceremony with the winners of the 12th Padma Vibhushan NA Palkhivala National Virtual Moot Court Competition and Research Paper Competition 2022-23. The winners for this competition are TC44, which is Rajiv Gandhi National University of Law, Punjab. Congratulations. Next, The first runners-up of this competition are TC47, School of Excellence in Law, Tamil Nadu, Dr. Ambedkar Law University. Congratulations. The next award is the second runner-up, which goes to TC41, which is National Law University, Bhopal. Congratulations, participants. The next award is of the best speaker, which goes to TC13, Medha Chiranewala, who is from the Department of Law, University of Calcutta. The next award is for the best memorial petitioner, which goes to TC41, National Law University, Bhopal. The next award is for the best memorial respondent, which also goes to TC41, National Law University, Bhopal. Next, the best research paper in the professionals category. The first rank goes to Sukh Sagar Sayal. Congratulations. The next award is for the second rank in the best research paper professionals, and that goes to Istiaq Ahmad. The next award is for the third rank in the best research paper professionals category, and there is a tie between Krishna K and KV Padmanabhan. Congratulations, participants. The next round of awards is for the best research paper students, wherein the first rank goes to Tanu Priya. The second rank goes to Tejaswini Sundar and Sushmita Senthil Kumar, a tie between the two of them. The last award for the day is for the best research paper students, third rank, and that goes to Samay Jain. Congratulations, participants. I request all the winners to turn on their cameras so we can congratulate them. Congratulations, participants. I want you to keep your camera for 1 minute. We will be taking a picture. Before we proceed with the vote of thanks, I would like to take this opportunity to showcase the souvenir for this event, the cover page as well as the last page of the souvenir. We've been blessed to have Professor Aman Khare as our mentor and faculty in charge, who has been wise in his decisions and has led by example. I call upon him to deliver the vote of thanks.
It's certainly my privilege to. Am I audible? Yeah. It's certainly my privilege to propose the vote of thanks. So the program have been a very. It has been a successful program. I take this opportunity to thank first of all the chief guest of today's program, Honorable Justice Sonia Gokani, Gujarat High Court, and guest of honor, Honorable Justice Valmiki Mendes, Bombay High Court, for their taking out their time and giving us the opportunity to host them. And I would like to thank Mr. Mitesh Modi, uh, Chairman of AIFTP West Zone, President Mr. Vipul Joshi, IT80 Bar Association, Mr. Sunil Kushlani, President, GSTPM, our mentor, guide, and person who has guided on every small step, Mr. Srinivas Rao, Senior Advocate, sir, has been very wise enough to help us in every detail, small detail. Thank you a lot, sir. Mr. D.K. Gandhi, IFTP National President, Mr. K. Shriram, sir, um, and all other dignitaries who are present here and have helped us in hosting this program. Thank you, everyone. I would also like to take this opportunity to thank the Vice Chancellor and the Registrar of MLE Mumbai to giving us all the opportunities to come up with this program. And finally, all the students who have been working like tirelessly till late nights and helping us with this hosting this program. Thank you, everyone.
Thank you.
Thank you.
To the students.
Thank you so much, Aman sir. That marks the end of today's valedictory ceremony. Thank you so much for taking out time to attend this ceremony, as well as for those of y'all that tuned in to watch the finals. Congratulations to all the winning teams as well as the participants. Thank you.
Thank you.
Thank you.
Congratulations to the winners and the runners up. You all were great.
Thank you so much. Thank you so much.
Ma'am, I'll see you sometime.
Yes, thank you very much to all the organizers and congratulations to all the students.
Thank you. Thank you.
Wonderful it was to be the part of it. Thank you, Mr. Aman Khare and Mr. Modi, everyone. Thank you.
Thank you, ma'am. Thank you. Thank you, Shivram, sir. You are very helpful to us.
Thank you very much.
Thank you.
Thank you, sir. Thank you. Thank you very much, Amana.